if you're over 60, you've almost certainly gotten the pitch. Maybe it came as a letter in the mail, or a free steak dinner seminar, or a late-night ad. And it always sounds the same: get a living trust, or the courts will take everything, your family will wait years, and strangers will pick over your life savings. It's scary. It's meant to be scary. Because fear sells trusts. So today, I want to do the opposite. I want to sit down with you, calmly, and explain what these things actually are, what probate really is, and why it's usually less of a monster than the salesman says, what a living trust does and doesn't do. And the honest answer to the question everyone's really asking, do a sign need one, or is a simple will just fine? No pitch, no fear, no steak dinner. Just plain English so you can decide for yourself. Before we go one step further, let me lower the temperature, because this whole topic runs on anxiety. Here's the truth. Whether you use a will or a trust, your money is going to get to the people you love. Both of these tools work. They're just different roads to the same place, and one road happens to skip a toll booth called probate. That's really what this entire conversation is about. Do you want to skip that toll booth, and is it worth what it costs to skip it? That's it. Nobody is going to take everything. The government isn't lurking to grab your house. Once you see how the pieces actually fit together, the fear drains right out of it, and you're left with a simple, manageable decision. So let's walk through the pieces, one at a time. Let's start with the word that scares everyone: probate. Strip away the drama, and it's just this. Probate is the court process that happens after someone dies, where a judge confirms the will is valid, makes sure debts and taxes get paid, and then oversees handing out what's left to the heirs. That's all it is. It's paperwork, supervised by a court, to prove that your wishes are really your wishes, and to transfer things cleanly. For a lot of ordinary estates, it's fairly routine. The executor files some documents, there's a waiting period, and eventually the assets pass to the family. It is not a courtroom drama. Nobody's arguing in front of a jury. Most of the time, it's a clerk, a stack of forms, and some patience. So keep that picture in mind, because it's a lot calmer than the version in the sales pitch. Now, I'm not going to pretend probate is fun, because there are 3 real downsides, and it's worth being honest about them. First, time. Probate can take anywhere from a few months to well over a year, depending on your state and how complicated a state is. Your family may wait a while before everything is settled. Second, cost. There are court fees, and often attorney or executor fees, and in some states, those are figured as a percentage of the estate, which can add up. And third, this is the one that bothers people most: probate is public. The will becomes part of the court record, which means a nosy neighbor or a distant relative, or frankly anyone, can look up what you had and who got it. So the fear isn't made up, it's just exaggerated. For a modest, well-organized estate, probate is a speed bump. For a bigger or messier one, it can be a real headache. Knowing which one you have is most of the decision. So let's put the 2 main tools side by side, as simply as I can. A will is a document that says who gets what after you die and who's in charge of carrying that out. Here's the key thing people don't realize. A will does not avoid probate. A will is basically your instruction letter to the probate court. It's essential. Everyone should have one, but it still goes through that court process. A living trust is different. Think of it as a container you create while you're alive. You move your assets into the container, you stay in complete control of everything in it, and you name who should receive it when you're gone. Because the assets are held by the trust, not by you personally, there's nothing for the probate court to process when you die. It passes directly to your people, privately, no court required. Same destination. One skips the toll booth. Let me be specific about what a revocable living trust actually buys you, because it's 3 things, and the third one is the one nobody mentions. 1. It avoids probate for anything you put inside it, so your heirs skip that court process. 2. It's private. Because it doesn't go through the court, there's no public record of what you had or who got it. And 3. The underrated one. A living trust helps if you become incapacitated, not just when you die. If you have a stroke or slip into dementia, the person you named, your successor trustee, can step in and manage the assets in the trust for your benefit, without going to court for guardianship. That living protection piece, while you're still here, is honestly one of the best reasons to consider a trust. And it's the one the scary ads always forget to mention, because it isn't frightening enough. Now here is the single most important thing in this entire video, and it's the mistake that quietly wrecks people's plans. A living trust only works for the assets you actually put into it. This is called funding the trust, and it means going through and retitling things. Your house, your bank accounts, your brokerage account, so they're legally owned by the trust instead of by you personally. Here's what happens far too often. Someone pays good money for a beautiful trust document, feels relieved, puts it in a drawer, and never retitles a single thing. So when they pass, the trust is an empty box. Nothing's in it. And every asset they thought they protected sails right into probate anyway, the exact thing they paid to avoid. So if you get a trust, funding it is not optional homework. It biddy sits the trust. An unfunded trust is just an expensive stack of paper. Before you decide you need a trust at all, here's something the pitch never tells you. Some of your biggest assets already skip probate for free, and you don't need a trust for them. Anything with a named beneficiary passes directly to that person, outside of probate, automatically. Your retirement accounts, your IRA, your 401k have beneficiary forms. Your life insurance has a beneficiary. When you die, that money goes straight to whoever's named, no court involved, trust or no trust. This is huge because for a lot of retirees, those accounts are the biggest thing they own, which means a big chunk of your estate may already avoid probate today for nothing. So, step 1, before you spend a dime on fancy documents, is simple. Check your beneficiary designations, make sure they're filled in, and make sure they're still the people you actually want. An out-of-date beneficiary form has sent many an inheritance to an ex-spouse. There's a second free probate avoider, and it covers your plain bank and brokerage accounts. It's called Payable on Death, or POD, for bank accounts, and Transfer on Death, TOD, for investment accounts. It's a simple form you fill out at the bank or brokerage that says, when I die, this account goes directly to this person. Just like a beneficiary designation, it passes outside probate, immediately, no court. You stay in total control while you're alive. The named person has no access at all until you're gone, and then it transfers cleanly. Many states even allow a transfer on death deed for your house now, though that one varies a lot by state, so that's a question for a local attorney. The point is this: between your beneficiary designations and POD and TOD on your accounts, a surprising amount of a normal estate can be set up to skip probate without any trust at all. Sometimes that's genuinely all you need. So let's answer the real question. Who can get away with just a good will, plus those free beneficiary tools? Honestly, a lot of people. If your estate is relatively straightforward, say you own one home in one state, your accounts already have beneficiaries and POD set up, your wishes are simple, and your family gets along, then a solid will, kept up to date, may be all you need. Yes, whatever's left in your personal name still goes through probate, but if that's a small slice and your state's process isn't burdensome, that speed bump may be perfectly fine. Not everyone needs the deluxe package. For plenty of ordinary retirees, a clear will, current beneficiaries, and a well-organized folder of documents is a completely reasonable, grown-up plan. Don't let anyone shame you into thinking you failed your family if you don't have a trust. That said, there are real situations where a living trust genuinely earns its cost, and here are the big ones. If you own real estate in more than one state, a home and a vacation place, say, a trust can spare your family from going through probate separately in each state, which is a real hassle. If privacy matters a lot to you, a trust keeps everything off the public record. If you have a blended family and you want to make sure, for example, that your kids from a first marriage are protected, a trust gives you far more control. If you have a child or grandchild with a disability, or one who isn't good with money, a trust lets you spell out exactly how and when they receive their inheritance instead of handing it over all at once. And if you simply want that incapacity protection we talked about, the trust does that too. See the pattern? A trust is about control and complexity. The more moving parts your life has, the more a trust is worth it. Let me knock down 3 myths quickly because they cause a lot of bad decisions. Myth 1, a living trust saves you on taxes. It does not. A revocable living trust has no effect on your income taxes while you're alive, and by itself, it does not avoid estate tax. It's a probate tool, not a tax dodge. Myth 2, putting your assets in a trust means losing control of them. Also false. With a revocable trust, you are the trustee. You can buy, sell, spend, and change your mind anytime. Revocable literally means you can undo it whenever you want. Nothing changes in your day-to-day life. And myth 3, a revocable trust protects your money from creditors or nursing home costs. It does not. That's a completely different, much more restrictive kind of trust called irrevocable, which most people don't need and shouldn't rush into. If a salesperson blurs those together, that's your signal to slow down. Here's a small but important piece that trips people up, and it pairs with the funding step we talked about. Even when you set up a living trust, you don't throw your will away. You get a special kind of will that goes with it, often called a pour-over will. Think of it as a safety net. Its job is to catch anything you forgot to put into the trust, some account you opened later, a car you never retitled, and pour it into your trust after you're gone. Now, here's the honest catch. Anything the pour-over will has to catch usually still goes through probate first, before it lands in the trust. So it's a backstop, not a substitute for funding. It's there to make sure a stray, forgotten asset still ends up following your wishes instead of getting lost. Lesson is the same one from before. Fund the trust properly while you're alive, and let the pour-over will be the net you hope you never need, not the main plan. Let me touch that last point for just a moment, because the word irrevocable gets thrown around to scare or impress people. Almost everything we've talked about today is a revocable living trust, the flexible kind, where you stay in charge and can change it anytime. That's what fits the vast majority of ordinary retirees. An irrevocable trust is a different animal. Once you put assets in, you generally can't take them back out or change the terms because you've given up control on purpose, usually to shield assets from estate tax or long-term care costs. That can make sense for a small number of people with specific situations, but it's a big, permanent step with real trade-offs, and it is absolutely not a do-it-yourself project. If anyone suggests an irrevocable trust, that is precisely the moment to sit down with an experienced estate attorney and go slow. For most of you, revocable is the whole conversation. Let me make this real with two quick pictures. First, meet Carol. She's 70, widowed, owns one modest home, and has an IRA and a savings account. Her IRA already names her daughter as beneficiary, and she adds a payable on death to her savings. She gets a simple, up-to-date will for everything else and organizes her papers in one folder. Carol probably does not need a trust. Her plan is clean and mostly skips probate already. Now meet Tom and Linda. They own a house in Michigan and a condo in Florida. Tom has kids from a first marriage, and they want to control how the grandkids inherit. For them, a revocable living trust makes real sense. It avoids probate in 2 states, keeps things private, and lets them spell out their wishes. Same tools, 2 very different answers. That's the whole lesson. It's not about what's fanciest. It's about what fits your life. Let's talk money, plainly. A basic will can be very cheap. There are reputable online services for well under $100, and for simple situations that can be fine. Full living trust package prepared by an estate attorney typically runs more, often somewhere in the range of $1,000 to a few $1,000s, depending on your state and complexity. So the honest question is whether skipping probate and getting that privacy and incapacity protection is worth that one-time cost for your situation. Carol, probably not. For Tom and Linda, easily. My general take for anything beyond the simplest estate, or if real estate, blended families, or a special needs heir are involved, paying an estate attorney in your state is money well spent. Because a trust done wrong or left unfunded is worse than no trust at all. This is one of those places where cheap can get expensive. So here's how to actually decide in a few calm steps you can start this week. First, get the free stuff right. Check every beneficiary designation on your retirement accounts and life insurance, and add payable on death or transfer on death to your bank and brokerage accounts. That alone handles a lot. Second, make sure you have a current will. Everyone needs one, trust or not. Third, honestly assess your complexity. One state or several, simple family or blended straightforward heirs or someone who needs protection. If you're on the simple end, a will plus those free tools may be plenty. If you're on the complex end, put talk to an estate attorney on your list. And fourth, whatever you choose, tell the person you've named where the documents are. Perfect plan nobody can find is not a plan. None of this is urgent scary. It's just a few grown-up errands. Let me step back, because there's a lesson here bigger than trusts. So much of protecting your family isn't about buying the most expensive product someone's selling you out of fear. It's about understanding the tools, matching them to your actual life, and getting the simple things right. The beneficiary form, the current will, the organized folder, the conversation with your kids. People who leave a mess behind usually aren't the ones who skipped the fancy trust. They're the ones who never filled out the free beneficiary form, or who bought a trust and never funded it, or who never told anyone where anything was. Calm beats fancy. Clear beats complicated. You don't need to be scared into a decision. You just need to understand your own situation and take a few steady steps. Let's bring it together. Probate is just the court process that transfers your estate. Routine for simple estates, but slower, costlier, and public, which is why some people want to avoid it. A will is essential, but still goes through probate. A revocable living trust skips probate, keeps things private, and helps if you're incapacitated, but only if you actually fund it by retitling your assets. Before you even consider a trust, get the free probate, avoider's right, beneficiary designations, and payable on death and transfer on death on your accounts. Simple estate may need only a will plus those. A trust earns its keep with multiple properties, privacy needs, blended families or heirs who need protection. The revocable trust is not a tax dodge and doesn't cost you control. Here's the one honest takeaway. Do not let anyone scare you into an estate plan. Whether you need a simple will or a full living trust comes down to how complicated your life is, not how frightening a salesman can make the courthouse sound. Get the free things right first. Get a current will, and if your situation has real moving parts, sit down with an estate attorney in your state and get it done properly. Estate and probate law varies a lot from state to state, and these are general examples, not legal advice. So please use this as a starting point for a good conversation with a professional, not as the final word. Take care of the simple steps, tell your family where the papers are, and you've done the loving, grown-up thing. I'm Daniel Brooks. Keep it calm, keep it clear, and I'll see you on the next one.